Good day, viewers. This is another episode of Tommy Talks Legal. Kindly subscribe to my YouTube channel, click on the like button, and share generously with your audience. So, today we're going to be having another very interesting topic. And for me, I will say it's going to be an enlightening one. So that when you are buying properties or they present any document to you that is related to the title of a property, you would understand, you would have an idea what that document is saying, or a kind of history or a knowledge of that property. So today, our topic for today is land titles and their implications. So in all of the numerous land titles available, I will be discussing about 9 of it. So first of all, which is the popular one, the certificate of occupancy. Whenever people hear or discover that a property has a certificate of occupancy, they are usually at peace, like there's a kind of rest that comes, which should not be, because most of the times too you could have, or oftentimes you could have situation whereby the certificate of occupancy is either fake or some form of encumbrance. It's already on that title. However, we are not going to be discussing that today. So a certificate of occupancy is a legal title that is obtained from the state government. So which means that if you buy a property in Lagos here, you go to the land registry of Lagos State, or you buy a property in Kano, or you buy a property in Ibadan, or you buy a property anywhere in Nigeria, the state wherein that property lies is where you will go to the land registry to process the certificate of occupancy, which makes you a legal title holder. This only depicts that the government has given you 99 years legal ownership or legal interest or legal title in that land. So that is what a certificate of occupancy actually depicts. So another title we're going to be talking about is the governor's consent. Now, when you hear governor's consent, it gives you a knowledge that this property, as at when the current owner or current vendor or current seller wants, at the time when the current seller purchased that property had a C of O, which is the certificate of occupancy. So when you hear governor's consent, it means that when this person bought the property, they are to seek the consent of the governor to make the purchase or sale transaction between the previous owner and the current owner legal. So that is what the governor's consent means. And it means that at the time where the current seller was buying, they bought that property with the title certificate of occupancy. So what other property titles do we have? We have the land purchase receipt. For me, a land purchase receipt is an equitable title which is contestable. So it doesn't mean that other titles, whether legal or otherwise, is not contestable, but the chances where all things are equal, where there is no defects or challenge whatsoever, most legal titles are always incontestable. But equitable title can be contested on all grounds most of the time. So a land purchase receipt is just an evidence, like your normal receipt, that shows to every person that, a land transaction or a purchase transaction or a sale transaction has taken place. And this is usually given from either, most of the times, the omoniles to the current or to the buyers, or from the owner to the buyer. So most of the time, it may not be from Omonile, but most of the time, a seller to a buyer, you have to show that there is an evidence that this property has moved from the seller to the buyer. So that is what the land purchase receipt depicts, and it is not a legal title. So the fourth document that I also want to mention is the letter of administration. You know, last week we spoke about the next of kin, or who is your next of kin. Now, most of the time, the next of kin is the one who starts, most of the time, starts the letter of administration process. So whenever they tell you that a property has a letter of administration, it shows that that property was inherited. So which means that that property has passed from the original owner to the heirs, descendants, which may be the father, mother, siblings, children of the original owner, or the beneficiaries of the original owner. So once you see a letter of administration, it means that the original owner died without a will. So a letter of administration has to be processed or obtained so that the rightful heirs can have ownership or legal ownership to the property. So another title which I want to mention, which is similar to the letter of administration, is the grant of probate. So when they tell you a property has a grant of probate, it shows that the original owner died testate, which means this person died writing a will. So the executors have obtained a grant of probate to pass on that property or that estate to the beneficiaries. So once you hear that a property has a grant of probate, this is what it means: that the original owner is dead, the original owner died with a will, and the will already has executors, and the executors have processed a grant of probate at the probate registry, and that is a solid or valid title for them, or that the beneficiaries can use in transferring ownership from the seller to the buyer, or transferring ownership from themselves to the buyer. So the sixth title I want to talk about is the survey plan. But for me, I do not consider a survey plan as a title, even though some persons or some sellers uses a survey plan in transferring title to the buyer. However, when you're transferring such title, when you are buying a property with a survey, ensure that it is accompanied with a deed of assignment. So a survey plan only shows the boundary measures. So if this property measures one plot, it measures two plots, and they write the name, and it carries the name of the owner. Now, for you to do a survey, you require the services of a surveyor, and this is the survey plan, or a registered survey plan, or a survey plan that has a reg copy, has already been lodged at the Surveyor General's office. But most times, people usually consider a survey as a title. So most of the time, when you ask them, what is the document on this property, they'll tell you survey and receipt. Another title that I would like to talk about is the judgment of court. So when they tell you that there is a court judgment on this property, what does it tell you? It tells you that that property used to be a disputed land, and the original owner or the current owner won the title or won ownership to the land in court. Permit me to use that English, which means that there used to be an adversary to that property. So when you hear a court judgment, it is in as much as it creates an atmosphere of buyers beware, but it also shows that this person went to court. This property used to be a disputed land. The buyer, or the seller, went to court and has gotten judgment in favor that he or she has title or legal interest in the property. So what other title am I going to be talking about? I want to talk about the deed of assignment or your deed of conveyance, which is popularly known. Now, a deed of assignment is a document that shows that title or this property has been purchased or this property has been transferred between the assigner to the assignee, or in a normal parlance, between the vendor to the purchaser. Now, it is an agreement. Now, it is better. Most people have seen situations whereby people tell you that this property has a deed of assignment, or the title to this property is a deed of assignment, but it has not been registered. It's a title, but it only becomes legal or legal when this document has been registered at the land registry with the registrar of deeds. It makes it a better title, yes, to an unregistered deed of assignment. So I would advise that if you have that deed of assignment at home or to your property which you are yet to register, kindly register it at the land registry before you begin the process of obtaining a certificate of occupancy. The last title I want to believe that I'm talking about today is going to be the assets, deed of vesting assets. Now, when you see a deed of vesting assets, it doesn't go alone. It has to be accompanied either with a grant of probate and a letter of administration. This also still shows that the original owner of this property is deceased, and this property has been inherited by the heirs of the original owner, which is also a good title. Regardless of whichever title a property is said to have, it is normal, it is paramount that you as a purchaser always do your due diligence. Employ the services of professionals, which is usually a lawyer, to carry out the due diligence on each of the title, whether this property has a legal title or equitable title. Ensure that due diligence is done, because due diligence for every of those documents varies. So there is no hard and fast rule to doing due diligence. So if you have a certificate of occupancy, there's a tailored due diligence that should be done. If you have a deed of vesting assent, there's a due diligence that should be done. If you have a purchase receipt, there's a due diligence that should be done. So if peradventure you come across a governor's consent or a certificate of occupancy, it does not ultimately guarantee you that that title cannot be contested. So I would advise that always ensure that you do your proper due diligence before you invest your money in purchasing that property. So if this episode or if the session has been insightful enough for you, kindly again subscribe to my YouTube channel, click on the like button, and share generously with your audience as we have another interesting topic for you next week. Thank you.